raw agarbatti plant in Dimapur to Mr. Rikhiraj Gogoi's traditional lordship. As per deal, the machinery were supposed to be delivered within 60 days of the complete payment lordship. Complete payment, which he failed. I failed lordship. Based on that, he mailed us, stated that either he will deliver the machine by 20 August so and so or refund the amount by so and so. Later, he also provided us fake transportation bill. Lastly, he has issued a check number so and so, which was later stopped by himself only. Therefore, I hereby request to kindly register as so and so. This is the case, Lordship. Now, Lordship, I'm come on details. Before coming to your Lordship, we filed this case before the London Court, Lordship, as a discharge hearing, Lordship. There is a page number 24, Lordship, and Annexure number 4, Lordship. Our petition was not considered, and accordingly, I appeared before your Lordship. Annexure 24, Annexure 4, Lordship, page number 24, Lordship. Lordship. Let me come with details, Lordship. Kindly come to page number 49, Lordship. Annexure 6. Very inception of the issue, Lordship. Annexure 6, page number 49. This was the quotation, Lordship, regarding delivery of machinery, and the amount has been noted below, Lordship. That is 25 lakhs 19,033, Lordship. Page number 49, Lordship. From here, this is the issue will be evolved, Lordship. 25 lakhs 19,300, Lordship. Day after, Lordship.
No, what is your ground for question?
Yes, Lordship. Since I have to deliver the machinery within 60 days, Lordship. And moreover, Lordship, after receiving full and final payment. Yes, full and final. Amount has credited to my account, which is reflected in page number 50, Lordship, Annexure 7, Lordship. Annexure 7, page number 50. These are the amount credited to my account, Lordship. As soon as, Lordship, the quotation amount, I'm coming to precise, Lordship. Kindly, Lordship, bear with me. Yes, Lordship. Come to page number 51, Lordship. 51, Lordship. Page number 52, there is Lordship, in page number 52, Lordship, there is the first transaction. That is no, Lordship. That is 51. 13/4/2021, Lordship. 1,88,300 crore, 300 credited, Lordship. Again, 13/4/2021, 10,71,000 is credited, Lordship. Again, Lordship, in page number 51, there is 29/3/2021, 12 lakh has been credited. Now, Lordship, since machinery should have been delivered after receiving all the entire amount, Lordship. What happened, Lordship? As soon as the amount has been credited to my account, Lordship, the informant asked me to repay, to return few amount, Lordship. That is also, Lordship. Why? There is page number 52, Lordship. He asked me to return. As accordingly, Lordship, I returned 2 lakhs, 3 lakhs, in total 5,95,000. That has been reflected in the draft sheet, Lordship. Since after receiving the entire amount, Lordship, I am supposed to deliver the machinery to the private responsibility. But in the meantime, whatever the amount has been credited to me, Lordship, he asked me to return that amount. with the promise that I will return, I will give you within a period of so and so dated, so that you can deliver me the machinery. 5,95,000 he has taken from me, Lord. It has reflected in the charge. After that, what happened, Lordship? They again put me that I deceived them. I do not deliver the machinery in time. Whereas, Lordship, it has been material until receiving.
Why charges under 468 and 471?
Yes, Lordship. I totally denied fight from the very inception, Lordship. Why? Because there is also a question, Lordship. Transportation charges 1,30,000, Lordship. 1,30,000. And prior to that, Lordship, coming to you.
No. What is your case? That the
Two set of case, Lordship. They have issued me a they asked me to deliver a machinery.
whether they have filed a enact case?
No money suit. Instead of going to enact, they go to money suit, Lordship.
They can file money suit. There is
Yes, they can file. There is no, but instead of going to the money suit, they have filed the Lordship. They, instead of going to the money NI Lordship, they come to
But
the
charges are framed against you.
yes,
You
Lordship.
have not challenged that.
I've challenged Lordship. I've in the there is in page number, Lordship. Yes, Lordship. There is annexure number annexure number, Lordship. Annexure 4, page number 25, Lordship. 24 page number.
What is this?
This is the Lordship. But in this case, Lordship, I prayed for discharge, Lordship.
But that discharge was
No.
not allowed.
Yes, Lordship.
We have not preferred any revision against that order.
No, Lordship. As a whole, I come before your Lordship. As a whole, Lordship. There is a ground, very good ground, Lordship. Unnecessary, they have every time they have made a proposal, every time they have rejected, is their inception also to default of the entire issue, Lordship.
At what stage the case is pending evidence?
As no, Lordship, it's charge, Lordship.
Charges are already framed.
Not framed, Lordship. Fixed for framing. It is on 18/3/2025. Fixed for framing, but that day also not framed. No? We have taken a judgment since we are prepared for coming before Lordship. Not framed, Lord. Entire issue is of documentary, Lordship. There is a civil of nature, giving a fake transportation bill from their story, Lordship. They are given a structure of a criminal proceeding, Lordship.
When is the next date fixed? First June.
Yes, Lord. So,
Yes,
Lord,
Miss Mary.
Application is already materialized into charges, so at least they should let notice go.
Lordship,
Okay, we are issuing notice.
Lordship, I have come before Lordship, at least Lordship, till returnable done matter me because parallel procedure are
Here
going.
the
we-
complainant. has
Lordship,
noticed
parallel
it.
procedure are going on.
I
Lordship.
will fix
Because what,
returnable date before 1st June.
Lordship, what happened? Parallel procedure are going on. Lordship.
No, listen to me.
Yes, Lordship.
Suppose I fix the returnable date in the month of May. Then how will you be aggrieved by not staying? Then what is to be stayed? We are issuing notice before that next fixed date. Heard.
B, Lordship.
Heard Mr. B.
Sinha, Lordship.
B. Sinha, learned counsel for the petitioner.
2nd of June, Lordship.
Huh?
2nd of June, that is fixed. Court below it. Trial.
Yes, I will fix this before that date.
Yes, Lordship.
Returnable. Also heard Miss S. Mary, learned public prosecutor, Nagaland. This application under section 528 of BNSS has been filed by the petitioner, namely Rikhiraj Gogoi, praying for quashing of the criminal proceedings of GR case number 384/2022 arising out of the FUPAR PS case number 38/2022 under section 420/468/471 of the Indian Penal Code. Issue notice to the respondents. Since Mrs. Mary has appeared for respondent number 1, no formal notice need to be issued to said respondent. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 5th of May. Is it okay? 5th of May. Stop. Let also the scanned copy of the case diary of DFUPAR PS case number 38/2022 be called for from the trial court. Registry to issue requisition. Registry to take steps for requisitioning the scanned copy of the case diary. List accordingly.
Okay, I have a prayer, Lordship. Finally, as on that date, Lordship, the interim prayer may be discovered. That may be discovered.
No, I don't get it. What?
Lordship, since I have the interim prayer for extending at least, Lordship, that may be reflected that they on the it will be this.
Let the notice be served on this.
Deeply well.
For hearing item number 20.
Wait, please, Lordship.
Yeah, you have patched up.
Lordship, it's all together a different matter.
Yes.
What you get, she's very limited.
Yes, Mr. Jamesh.
The petitioner in this writ petition is claiming the benefit arising out of revision of pay 2017, Lordship. More particularly, Rule 15, which says retirement come gratuity benefit, Lordship. I was denied that benefit, Lordship, which is why I'm here before the Honorable Court, Lordship.
When have you retired?
Yes, Lordship, I have retired in the year 2000. I was paid paid 17 lakh rupees, Lordship. That is my grievance, Lordship, in this case. May I take the Lordship to the revision of pay, Lordship,
Yes.
the relevant provision, Lordship. May can you come to page 12, Lordship, page 12 of
Yes.
this is the notice. In exercise of powers conferred by the proviso to Article 309 of the Constitution of India, the Governor of Nagaland is pleased to make the following revised rules in supersession of earlier notification number dated straight solo. rules. One, short title and commencement, applicability of the rules provided in the rule 2, and lordship, if I may be allowed to take your lordship to rule 15, lordship. Rule 15. What will find page number 23, lordship. Page 23. I'll read out only the relevant provision, lordship, from the rules. Page number 23. Rule 15, lordship. Rule 15.
Page
Page
23.
23, lord. Page 23.
Yes,
Pension and other retirement benefits, lordship. Rule 15, lordship.
yes,
And I'm concerned with clause E, Lord, you will find it next page, Lord, page 24. 15 talks about pension and other retirement benefits, and E, this is the maximum limit of death from retirement gratuity, Lord. Maximum, how much an
yes,
employee should be paid, Lord. So the maximum ceiling limit of death from retirement gratuity is raised from the existing level of 10 to 20, Lord. Earlier it was 10 before commencement of this ROP rules to 17. It has been enhanced to 20 lakh rupees. This rule shall also be applicable to those employees covered under the National Pension Scheme.
okay.
So after enhancement of from 10 to 20, I should be paid 17 lakh rupees. That is my contention, Lordship.
What is your date of retirement?
31st March 2018, Lordship. 31st March 2018.
After coming into force, this ROP of
Yes, Lordship. Yes, Lordship. Now, if your Lordship, if I may be allowed to pause there for a moment, and if your Lordship may, if I may be allowed to refer to the order dated 16/4/2024, 16/4/2024, passed by this honorable court, Lordship. And there, and direction was given to the Learned Government Council to
Order
get
of
some
the-
instruction, Lordship.
order of this court.
Yes, Lordship, order of this court. 16/4/2024, Lord.
Yes.
16/4/2024, Lordship. May I read it, Lordship?
Yes,
Miss so-and-so, Learned Government Advocate shall on the next day come with proper instructions as to how the petitioner's salary, who is an employee of the Development Authority of Nagaland, Dimapur, was fixed as per ROP rules 2017, with effect from 1st January 2018 till the month of March 2018. That is the date of retirement of the petitioner, Lordship. From 1st January 2018 till the month of March 2018. This instruction shall be filed in the form of an affidavit. In compliance of this, Lordship, an affidavit is already filed. I have received on 19th of March 2025. 19th of March 2025. This is an additional affidavit filed by the state respondents, Lordship. Respondent
19th,
number
19th March.
3, Lordship. Additional affidavit filed by respondent number 3.
Yes,
May I read, Lordship? Paragraph number 3. Paragraph 3, Lord, you will find at page number 2.
yes,
That pursuant to the approval order dated January 17, 2018, the revised pay order ROP 2017 was implemented for the staff of DEN. I serve under the Development Authority of Nagaland, Lordship, under this organization, effective January 1st, 2018. Consequently, the petitioner's basic salary was revised accordingly. So it was made effective ROP 2017. However, the enhancement of group gratuity could not be applied to the petitioner as it took only effective from his retirement. So they took a decision to make it effective only after my retirement, Lordship. As far as the gratuity is concerned, Lordship. Therefore, the petitioner is not eligible for the enhanced gratuity amount. As such, no discrimination has been meted out to the petitioner by not granting him the enhanced gratuity amount. That is the instruction filed by way of an affidavit, Lordship. They have also enclosed a document, page number 4, Lordship. This is order dated 17 January 2018. As approval of the Chairman Development Authority in Netherlands, ROP 2017 is hereby granted against pay and allowances of staff of DAN with effect from 1st January 2018. Clearly states it was made effective even for the employees of Development Authority of Netherlands. This is issued with reference to the Finance Department notification dated so. Employees of Development Authority of Netherlands.
Only with regard to pay and allowances.
Plain allowances. Plain allowances.
Okay. Now what is your submission?
Lordship, my respectful submission is February and March 2018, the last 3 months of my service, Lordship, I was given the benefit, scale, and other benefits arising out of the ROP 2017. Whereas, Lordship, only the provision, only the benefit arising out of that Rule 15, more particularly E, it has to also be applied. They cannot apply the benefits of a notification or a rules in a piecemeal, Lordship.
No, why it was not applied? What is the reasoning given?
They have made an averment in the at paragraph 3 of the affidavit
That it is effective. It could not be applied to the petitioner as it took effect after his retirement. What it means?
Lordship, there is no specific reason as why it was made applicable only after my retirement, Lordship. There's no reason as such. So it's a clear case of discrimination, Lordship. A clear case of discrimination. Because they have taken a decision to apply the benefits arising out of 2017 ROP. Whereas they cannot deny the benefit arising out of Rule 15.
No, but that order pertains only to pay and allowances.
Yes, Lordship. But the entire notification, Lordship, it has been made applicable, Lordship. They cannot take a contrary step.
Okay.
They cannot, Lordship.
Anything else?
Lordship. That is my
You have some authority.
Lordship. Yes, I have some authorities, Lordship. I'll rely upon some decision made in a similar case, Lordship. This is also pertaining to the same department, Lordship. This is passed by this honorable court, Lordship. 25th June 2024, Lordship. This order was passed in 3 analogous matters, Lordship. Lordship, may I read from page number 3? Page 3, Lordship.
Yes.
Paragraph 3, Lordship.
Yes.
All the 3 read petitioners were appointed as work church labor. White order dated so-and-so, with effect from so-and-so, in the year 1983, Lordship. The petitioner, after working for some time, were regularized in service. The petitioner in WPC number so-and-so as Mali by order dated so-and-so. The petitioners, after having completed 35 years of service, retired on superannuation white order dated so-and-so in the year 2000. Petitioners had overstayed in their service for a period of 34 months, though this was not the issue, Lordship. Upon submitting an application as honorary. 4. It is the case of the petitioners that upon their separation from service, they were given gratuity by counting their service only from the date of regularization, that is 5/8/2004, in respect of petitioner in so and 22/7/2010 in respect of petitioners in WPC number so. According to the petitioners, they are entitled to be given gratuity by reporting from the service with effect from the date their initial appointment, and there also being no break in their service. 5. Mr. So-and-so learned counsel for the petitioners by relying upon the case of Netram Sahus versus State of Chhattisgarh, and another reported in 2018, 5 SSC 430 submits that the apex court in the facts of that case held that the appellant therein was entitled to get gratuity from the date of initial appointment till the date of superannuation. He submits that petitioners in the present case are similarly situated, and therefore the same covers the case of the present petitioners as well. He thus submits that a read petition may be allowed as prayed for by the petitioners. 6. Mr. So-and-so, Leonard State Counsel on the other hand, by referring to the affidavit in opposition filed by the respondents, submits that the petitioners, upon attaining the age of superannuation, were granted one-time gratuity, and therefore they are not entitled to any further gratuity as claimed by them. He submits that the Development Authority in Nagaland is an autonomous body, and therefore, unlike the case referred to by the Learned Counsel for the petitioners, wherein the employers was the state government, the case of the present petitioner is not similar, and accordingly, they are not entitled to any more gratuity apart from the one-time already paid to them. To this submission, Mr. So-and-so Learned Counsel draws the attention of the provision of Payment of Gratuity Act 1972 and submits that the act applies to every factory, mine, oil field, plantation, port, and railway company, and also every shop or establishment within the meaning of any law for the time being enforced in relation to shops and establishments in which 10 or more persons are employed. This is important, Lordship. And where he submits that the act also encompasses the service rendered by the petitioners and the respondent 3 as well. Submissions made by the so-and-so, and also have produced the materials available on record. 9. The facts narrated by the petitioner broadly are not disputed by the respondents. The only dispute raises with regard to the claim of gratuity counting from the date of initial appointment as so-and-so. The apex court in the case of so-and-so Supra, in the given facts of that case, held that appellant had actually rendered service for about 25 years, and that his initial appointment as daily wager was regularized by appointing him to the post of pumped operator. The appellant, having continuous and uninterrupted service till he attained the age of superannuation, the respondent authorities cannot deprive him of the benefit of gratuity from the date of his initial appointment by restricting the same only from the date of his regularization, which was for only 3 years. Further, the apex court also held that no provisions under the act was brought to the notice of the court, which entitled the appellant from claiming gratuity, nor was any provision brought to the notice of the court which prohibits the appellant from taking benefit of this long and continuous period of 22 orders of service which he had granted prior to his regularization for calculating his continuous service of 5 years. Similarly, in the instant case, there is no dispute to the fact that the petitioners who were initially appointed with effect on so-and-so and thereafter regularized with effect on so-and-so are debarred from claiming continuity in service or from claiming gratuity under any provision of law. Under the circumstances, this court is of the view that the ratio laid down in the case in so-and-so is squarely applicable to the present cases as well. Accordingly, the respondents are directed to work out the gratuity payable to the petitioners with effect from initial appointment up till their regularization within a period of 6 weeks from the date of receipt of certified copy of this order.
It is a different case.
Lordship,
Here-
I understand, Lordship, understand. It is about whether the gratuity has to be paid from the date of initial appointment or from the date of regularization.
But
Lordship.
your case is that you want gratuity in terms of ROP 2017.
2017,
You have been paid gratuity of 10 lakhs
10 lakhs, Lordship.
according to earlier rules.
Yes, Lordship, earlier rules.
So
But after once the
this
latest
is not-
ROP is implemented, I should also get the benefit arising out of
How
that.
this case helps you? This case, facts are different, findings are different.
Lordship, there are two aspects that can be taken into consideration from this case, Lordship. Gratuity Act, Lordship. Section 7 of the Gratuity Act, if I may be allowed to refer, Lordship.
Yes.
Section 7, Lordship. This is, it provides determination of the amount of gratuity, Lordship. Behalf shall send a written application to the employer within such time and in such form as may be prescribed for payment of such gratuity. Lordship, I have approached on several occasions before the authority in compliance of this provision, Lordship. Subsection 2. As soon as the gratuity becomes payable, Lordship, the employer shall notice in writing to the person to whom the gratuity is payable and also to the controlling authority specify paragraph 11 of my writ petition.
Yes.
Stated regarding the determination of the amount, Lordship. Paragraph 11. It is submitted that gratuity is a lump sum amount an employer pays employee as a sign of gratitude for the services rendered. The gratuity rules are mandated under the Payment of Gratuity Act 1972. The amount of gratuity is determined by the total number of years served by an employee and the last drawn salary. For the sake of clarity, subject to rectification by the respondents, the petitioner begs to highlight the computation of claiming an amount of rupees 17,28,077 rupees by the petitioner for that retirement gratuity in the following manner by applying gratuity calculation method. This is the method. The calculation is based on the monthly salary divided by 26 and the result is multiplied by 15 and thereafter multiplied by the total number of years of service rendered. The multiplier 15 is the formula of wages for 15 days of last drawn salary for each completed year of service or part thereof in excess of 6 months and 26 being the number of working days in a month. Again, multiplier 35 uses the present case is the length of service of the petitioner. That is how the amount was determined to 17 lakh rupees, 28,077 rupees. The state has filed the affidavit on
The
two separate occasions.
ROP puts a ceiling only.
Ceiling, Lordship. So
Earlier
I
it
cannot
was
claim for the
Now
maximum
it is
amount.
20 lakhs.
Yes, Lordship, 20
So
lakhs. My contention is that
it cannot be more than 20 lakhs.
not more than 20 lakhs.
Where this formula has been provided?
Lordship,
In the,
Lordship, as the instruction received, Lordship, my client, he has approached the department, Lordship, the relevant establishment where they calculate this by using the formula, Lordship. And the state respondents, after filing two affidavits on two different
but what is the provision, rules, law by which prescribes?
with the assistance of the employer, it was determined, Lordship. And the state respondents, they did not dispute to this. To determine, there's a provision under the act,
If there is a fixed formula of determining the gratuity,
Lordship.
then state has to follow it.
Yes, Lordship.
But you have to also point out that this is the rule or provision which prescribes the formula how to determine gratuity. And that has been violated in your case.
Lordship, there is no violation as such. My contention is that there's
Violation,
no
that
violation.
means
There's no
it is
violation.
not properly calculated.
Violation in the sense, as far as the determination of the amount is concerned, there's no violation, Lordship. Because there is a clear provision under section 7 to determine by the employer. And it has already been determined by using the assistance of the employer only, Lordship, which has not been disputed by the state respondents at any relevant point of time, Lordship. And my issue is not with regard to the determination, Lordship.
About this, not applicable to your case. Is that the plea of the state? Therefore, you cannot get more than 10 lakhs.
Lordship,
Ten.
the plea of the state respondents is only with regard to the gratuity. They have categorically stated, admitted, Lordship, that ROP 2017 is applicable even in my case. I have also filed a reply, Lordship, where I have enclosed the enhanced scale of pay, which was granted to me for the last 3 months, because it was made effective only from 1st January 2018. So I served,
No.
Lordship,
My query is,
Lordship.
while denying you the gratuity
Lordship,
in terms of the ROP 2017,
Lordship,
state has only stated in its affidavit that the gratuity is applicable to you only on the date of retirement. No. What is the stand of the state?
stand up to state, if I may be allowed to read it again, Lordship, the
Yes.
affidavit, additional affidavit, spotted number 3. Paragraph 3, Lordship. Additional affidavit filed with state respondents, paragraph 3, page number 2, Lordship.
That it only took effect after his retirement.
Lordship,
What it means?
no reasons, Lordship. They
As-
have made applicable the ROP rules, whereas only for gratuity, it made applicable only after my retirement. Apparently, it shows that they were waiting for my retirement to make it applicable, Lordship. This is not a clear
No,
case of
no.
discrimination, Lordship.
What it means, it only took effect after his retirement. Is it a notification that in case of pension and
Of course, gratuity.
yes, Miss Livika?
Chief, how the case of the petition could not be considered, Your Lordship, we have to, I have to, firstly, take you to my annexures, Your Lordship.
Okay, then let him
Yeah,
complete.
that's a very, let
You
him complete.
In that case, Lordship, if I may allow to take the Lordship to paragraph 12 of my petition, Lordship, paragraph 12.
No, in their additional in their affidavit in opposition,
Lordship,
their only plea is that they are denying you the gratuity as per 2017
Lordship,
because it took effect after his retirement. No other plea.
Lordship, a thought that really provokes as far as this statement is concerned, Lordship. Can the rules made applicable in piecemeal, Lordship? Can the benefit arising out of 2017 was applicable in my case? The scale of pay, whereas for gratuity, I fail to understand from which source they got this strength to take this decision, Lordship.
Yes. What is the basis? Basis is not reflected here.
Lordship, there's no reasoning at all. In fact, there's ambiguity, Lordship, in that
Lordship,
statement.
I've given the reason in my affidavit, Your Lordship. The, not on additional affidavit, I've just reiterated only. The reason why we could affect.
No. I'll come to you.
Yes.
Let him complete. Yes, anything else?
Lordship, only to that aspect.
No,
Lordship.
you're
They have
relying,
not assigned any reason.
and
why?
you're relying on only that one judgment. In case of autonomous bodies,
Lordship.
whether ROP is applicable,
Do that I have some authorities, if I may be allowed to, Lordship. If that is the question coming from this honorable court, I have some authorities.
that may be okay.
I'll
Reply.
yes, Lordship, I'll reply accordingly, Lordship. If
Yes.
I may be allowed to read there, because as far as the accountant general is concerned, Lordship, I haven't found an affidavit, but the petitioner is from the public sector. It's a government undertaking, that development authority plan, and it's a private sector, public sector. So we don't, AG don't deal with retirement benefit of
Those also it's
Who calculate, who gives?
it's the development authority. They have their own rules. They do it.
Okay, then you are not a party to this.
Actually, I'm not a party in the case, Roger, but I've sought for deletion of my name. But that has been
Retirement benefit, including the pension also.
everything is under the authority.
Okay, you
Development.
even
So-
don't deal with pension.
Yes, Roger, and in fact, we have let's written the letter to the chief secretary also. Or let me please record. We may be of some assistance to record.
Okay, you do not deal with employees of public sector.
Yes. We are all on the regular conference.
You are for respondent number?
Oh, that's one of them.
Okay. Yes, Miss Levika. Yes.
Yes, Your Lordship, Lordship, the coming, my learned friend has already stated, Your Lordship. The petitioner is serving under
Development
yes,
Authority
Your
number.
Lordship, and it's an autonomous body, Your Lordship. And Your Lordship, if you can kindly come to my annexure 1, Your Lordship.
Your affidavit in opposition.
This is the.
Where respondent number 3.
Right,
Yes.
page
Page.
6. Page 6, Your Lordship, I may not read the content, Your Lordship, but page 6, annexure 1 is the first appointment of the petitioner, Your Lordship. The reason why I'm actually pointing out all these things, why I'm showing about the appointment order of the petitioner, it will become relevant at the later point, that's why you're watching.
Yes.
Your Lordship, this is the first appointment. The appointment is done by the developing authority, Your Lordship. Kindly note that, Your Lordship. He was on work charge at the initial point, Your Lordship. The type copy is at page 7.
Yes.
And after that, annexure 2, page 8, Your Lordship. That is also again a continuation of the previous order, Your Lordship. That is also given by the developing authority, Your Lordship. We'll just go like this, Your Lordship. And page 3, 9, again, continuation, Your Lordship. And annexure 4, page 10. It is a promotion order of the petitioner, Your Lordship. Annexure 5, page 11 is also a promotion order, Your Lordship. Appointed by the chairman of developing authority, Your Lordship. The reason why actually I'm bringing all these things is because, Your Lordship, the petitioner is governed, Your Lordship, by the statutory rules of developing authority, Your Lordship. Now, if we can kindly come to page 25. Page 25. Your Lordship. Annexure J. I mean, rule J. Page 25, Your Lordship.
Yes.
J column, Your Lordship. Clause 2. The officers and employees of authority shall be entitled to receive such salaries and allowances as may be fixed by the authority and shall be governed by such terms and conditions of service as may be prescribed by the authority.
Okay.
Your Lordship, that's why, Your Lordship, the service conditions of the petitioner is governed by this rule. They are governed by the authority as per, and the salary allowances, everything is fixed as per prescription of the authority, Your Lordship. Now, coming to the contention, Your Lordship. The petitioner is stating that he has not been given the enhanced gratuity. Your Lordship, the reason why we could not able to give is because the petitioner retired on 31/3/2018. The petitioner retired on 31/3/2018, Your Lordship, March 2018. And if we can come to my annexure now, Your Lordship, page 26, annexure 9.
Yes,
May I read, Your Lordship?
yes,
Meeting minutes of then trustee board held on 20 August 2018. 20 August 2018. This meeting is held much after the petitioner was retired in the office chamber of secretary.
what was decided?
It was, Your Lordship, the meeting of the Board of Trustees of Developing Authority then was held in the office chamber of secretary, vice so-and-so, dated 20 August 2018 to discuss on the matter relating to the contemplated increase in the ceiling of on payment of gratuity amount to the employees on retirement from service under Gratuity Act 1972. In the so-and-so presides over the meeting as the president of the committee. In the meantime, the following so-and-so, the following officer attended. On the next page is the resolution, Your Lordship. This is the meeting minutes. The person who have appointed attended the meeting. The next page 27 is the resolution of the meeting. May I read, Your Lordship?
Yes,
After thorough discussion on the matter, it was resolved to implement the revised enhancement of gratuity scheme from the existing scheme amount of 10 lakhs only to the upper ceiling of 20 lakhs as per the ministry order issued in the Gazette so-and-so in exercise of the power conferred by subsection 2 so-and-so of the payment of gratuity so-and-so and the government of Nagaland ROP rules 2017, serial number 15, pension and other retirement benefit, serial number E, maximum limit or death come retirement gratuity is raised from the existing level of 10 lakh to 20 lakh. For the employee retiring, if the requirement amount is not sufficient, then it shall be met in turn wise as per their seniority. Regarding any confusion in respect of the mentioned matter, the committee has decided to send representative from the accounts branch to the concerned authority to check and do the needful. The meeting ended with a lot of things. Now, after this, Your Lordship, no, next page, Your Lordship. The meeting was taken up on, resolution was taken up on 20 August 2018 to implement the gratuity amount, Your Lordship, the scheme to the upper ceiling of 20 lakhs, Your Lordship. Now, after this, Your Lordship, a letter was sent, Your Lordship, on 20 September 2018 to the senior branch manager, Life Insurance Corporation, Your Lordship. Your Lordship, married. Sir, with due respect and humble submission, I have the honor to inform you the outcome of the Board of Trustees for the then meeting held on 20 August 2018. Copy includes. The committee discussed and approved the enhancement of gratuity amount for then staff for the present amount of 10 lakhs to the revised rate of 20 lakhs, Your Lordship. Therefore, I would like to request you to kindly do the needful from your side and intimate to our office for further and necessary action. Your Lordship, the enhanced amount will have to come from this senior branch, Your Lordship, because that is the procedure for the done, Your Lordship. And now there's a subsequent letter to the, since there was no reply, subsequent letter was sent to the senior branch, Your Lordship. Again on 25th March 2019, Your Lordship. Annexure 11, page 29. After that, Your Lordship, annexure 12, page 30, Your Lordship. Annexure 30, page 30, annexure 12, Your Lordship. Sir, with reference subject cited above, I have the honor to request you to kindly enhance the group gratuity scheme of developing authority to Nagaland staff from the present amount of 10 lakhs to 20 lakhs with effect from 1st April 2019. 1st April 2019, Your Lordship. So now the board took a decision, Your Lordship. They took up a resolution on 20th March and it was intimated to the senior branch, and only by letter 5th March, it was intimated to the senior branch that it will be made effective from 1st April 2019. Now, by the time this decision was taken, Your Lordship, the petitioner has already gone, Your Lordship, from the service, Your Lordship. He has already retired, Your Lordship. Now, how can we implement this in his case, Your Lordship? Because they are governed by the statutory rules and as fixed by the authority, Your Lordship. Their service conditions, Your Lordship, their salary, their everything, payment is and allowances, everything is fixed by the authority now. Your Lordship, if they are at all grieved, now they should challenge the rules now. Now, if they are, suppose if you go in that line, if you go in line with petition submission, then because all along he had been enjoying the service of the authority, and now at this point, then he knows the service conditions, Your Lordship, how the payment is done, Your Lordship. But now at this point of time, now he's bringing that he is not being given this amount, Your Lordship.
Okay, your submission is that ROP 2017 in itself is not applicable.
Your Lordship,
Unless-
only after the then takes a decision. Now, after this was filed, the petitioner raised an issue that no, there was an enhancement in my salary, Your Lordship, in my as per the ROP. That's why I sought for instruction. I told I made a submission before the Honorable Court that maybe the court has taken a decision, and therefore only after taking a decision taken by the board, maybe the salary was also enhanced, affected, Your Lordship. So after making an after writing a letter to the then, I got an instruction that the board, Your Lordship, they took a decision to implement the Lordship by additional affidavit. Additional affidavit, Your Lordship, page 4, annexure 1. Took a decision that, as per the approval of the chairman, developing authority ROP 2000 is hereby granted against pay and allowances of staff of then with effect from 1st January 2008.
Okay.
And therefore, since the petitioner was in service, well within the service, his payment was also affected from 1st January 2019. Now, Your Lordship, that is our submission. Like, where is the discrimination, Your Lordship? He wasn't well in service. If he was within the service, and if we have not given him, then yes, we have meted out discrimination against him. And he has a right to met out his grievances before this honorable court. But now, Your Lordship, we have already given, and 10 lakhs we have already given to him. At that relevant point of time, 10 lakhs was the position, Your Lordship. That was that was in force, Your Lordship. The board has not taken a decision by then.
Yes,
That's
is not
like-
according to ROP, but according to the
Yes,
decision of the board.
decision of the board, Your Lordship.
Okay.
So, Your Lordship, that's why, Your Lordship, we could not able to give it to him. That is the thing, Your Lordship. Now, they're also governed by the rules now. Now, how can, like, beyond the rules, whether the court, he can come before the court begging that I have that authority that no, this should be given to me. All along, he has been enjoying that benefit, Your Lordship. And he knows, maybe the petitioner, maybe, I don't know on what ground he is coming before this honorable court, but that is our reason, Lord, Your Lordship, as to why we could not able to give him the gratuity up to the upper ceiling of 20 lakhs. As rightly entitled, we gave him on the day of his retirement. There was no decision taken on that gratuity amount of upper ceiling of 20 lakhs. That's why the entitled amount of 10 lakhs was granted to him. But on the later stage, when after the board took a decision making it effective from 1st April 2019, Your Lordship, the employees have been given. Now, the petitioner in his affidavit has also taken one person's name, that this person has been given and why I am not being given. But this person retired much after the decision was taken. And therefore, as rightly, he as entitled, we have given him 20 lakhs, Your Lordship. So now where is the discrimination now? Now, if this court allows, then there not only the petitioner, there are many who has retired between this period. Now, if this petitioner allows, then again, many will come seeking this benefit, Your Lordship, when they are not entitled actually. So that is my position, Your Lordship. That is the reason why we could not able to give, Your Lordship. And the petitioner has the get satisfied, Your Lordship, has to satisfy this honorable court whether this rule that I have enclosed in this petition is governing him or not. If the petitioner could satisfy this honorable court on that ground, then I will not say. But if he says that he's governed by this rule, set of rules, they need to go by way as per the fixed amount means like, but fixed by the authority, only by the then authority. Only. Pay and allowance is fixed by the then authority.
You have made your point.
Yes, so let him satisfy the honorable.
May Lordship, just on that aspect, Lordship. Lordship, the situation could have been different, Lordship. If the applicability or effective date of RP 2017 was taken after the decision was made, Lordship.
No, ROP is not applicable. What is submitted by the Government Council is that ROP in itself is not applicable. It is the decision of the authority which binds, which is applicable. Authority took decision to, authority has not referred to ROP in its decision.
Lordship.
It has only increased from the 10,000 to 10 lakhs to 20 lakhs without mentioning about ROP.
Lordship.
So it is because of the authority's decision. Now you have to make a point that this decision as per the Nagaland Town and Country Planning Rules 1976 is not applicable, but ROP is applicable.
Lordship, on that ground, we have maybe allowed to refer to the reply which I filed, Lordship, petitioner's reply.
Yes.
Take your Lordship to page number 5, Lordship. Affidavit in reply filed by the petitioner, Lordship.
You have to help me. Definite reply by the petition. Yes. Page number
5, Lordship. Page number 5.
Yes.
This is a statement of salary, Lordship, of the petitioner, Lordship. It is for the financial year 2017 to 2018, Lordship. Lordship, I'm concerned with the last 3 months, Lordship. In the month of January, February, and March 2018, Lordship.
Now, what is the point which you want to emphasize?
Lordship, my point is, Lordship,
Your salary was
before,
increased.
before the decision was taken, apparently
The salary was increased.
salary was increased in terms of the RP 2017.
Maybe, but by calculating, taking into consideration increased salary, the gratitude comes to 17 lakhs.
Lordship,
But at that point of time, the ceiling was 10 lakhs. This ceiling was increased only in the month of August with effect from April next year. That decision was not there when your salary was increased. You are bound by the rules of the, are you bound by the rules of the?
equally bound by both, Lordship, RP rules and also the act which the statute which was relied upon, Lordship.
No.
Now, Lordship, even otherwise, Lordship, if a decision is taken, Lordship, apparently, Lordship, assuming that a decision was taken without referring to the rules of 2017, Lordship,
Yes.
that benefit can also be given retrospective effect to the petitioner.
implementation of every decision. That decision was taken by the authority in the month of August 2018.
Effective on-
And it has not decided to give retrospective effect from when the ROP was implemented. It took decision to make it implement it from April 2019. So that was the decision. And that decision is not under challenge. You have not challenged that decision.
If that is the observation of the son of a court.
No, no, I am putting queries only. I am
Lordship.
not coming to conclusion.
Lordship, Lordship.
I have not decided anything.
Lordship, then I may be allowed to challenge that decision, Lordship. Because apparently I was given the benefit
You are
in the
at
month of-
liberty.
in the month of
So
January.
you want to withdraw this writ petition?
amend, Lordship, amend in my prayer, Lordship. Because I came to know about all the decision, Lordship, only once the affidavit was filed by the state, Lordship. And if that is the decision, Lordship, ignoring the rules of 2017,
No, because 2017 rule, whether it provides that it is applicable to publics.
Lordship, it very much comes under the definition of state under Article 12, Lordship. I have authorities, Lordship. And if the benefit is given to any regular employees that comes under the definition of state, I'm also entitled, Lordship. And it does not need any decision to be taken, Lordship. If that is made applicable in this case of any regular employees falling under the purview of state, Lordship, I become entitled from the day when this rules of 17 was
No,
made
no.
effective, Lordship.
Now, what is your prayer?
My
You-
prayer is,
you-
Lordship.
You want to, you have options.
Yes, Lordship. I have options. But I don't want to take chances, Lordship. I don't want to take chances if I may be allowed to challenge.
No, Your Lordship, I have an objection because, Your Lordship, this
Let-
affidavit was filed. This affidavit was filed. If he deems fit that no, this decision taken by the DAN is not, it is like I have been, it is a discrimination. Then he should have challenged it. He should amend the petition. But he came with another plea stating no. There is an pain analysis enhancement. It was effective in by January 2018. Why this?
Because
Why
unless that decision is put to challenge,
the petition should
Lordship,
not?
there is
Abundance of the goodness.
unlikely that you will get relief.
Lordship, in that case, Lordship, I may be given liberty, Lordship.
Withdraw.
Lordship.
They should not take me in the next list. Because so many affidavits have been changed. Actually, this is part, I don't have even a single copy. I have just got a.
Pardon, Lordship,
Your Lordship,
renter apology, Lordship.
now since he wants to withdraw, I think there's nothing to submit. However, all the service conditions, Your Lordship, the appointment order, why I showed is because all this appointment order has been subjected to, plus all adjourned are, as are admissible under development.
Yes. Apparently,
Enjoying the benefits as admissible by the authority, and now at this point, he said, no, this portion is not favorable to me, so I will not take. I think that should not be encouraged. Your Lordship. However, Your Lordship.
heard Mr. Muazzamir, learned counsel for the petitioner. Also heard Ms. Livika, learned counsel for respondent number 3. State respondent.
Your Lordship, I made a submission that even the respondents were. Findings. Right. In this case, I'm representing 1, 2, and 4.
1, 2, and
2 also is not applicable.
1,
No,
2,
no,
and
1, 2, and 4. 1, 2, and 3.
1, 2, and 3. As well as Mr. N. Muzoi, appearing for respondent number 4. Learned counsel for the petitioner has submitted that he has not put to challenge the mm, Which decision? Should I mention it?
It may not be quite a lot.
Yes. The petitioner intends to challenge the minutes of the decision of the resolution adopted in the Dan Trustee Board meeting held on 20th August 2018. Date of effect of $20 lakhs in respect of payment of gratuity to the retired employees of the Development Authority in Nagaland. And for that, he prays for allowing the petitioner to withdraw the instant writ petition with liberty to file a fresh.
Lordship.
The prayer is allowed. This writ petition is dismissed on withdrawal with the liberty sought for granted.
Very much obliged.
For hearing item number 22.
Please, Your Lordship.
Yes.
Lordship, this matter pertains to non-payment of damages caused to my properties during the construction of National Highway 29, that is between Kohima and Dimapur. And therefore, I'm before this honorable court seeking compensation, Lordship. Invoking 2226, Lordship.
Just a minute.
May I take Your Lordship to my facts?
Just a minute.
Lordship.
Where is your writ petition? Yes.
Lordship, the present land pertains to for the purpose of construction of four-lane road. And
No,
for that,
just a minute.
Lordship,
What is your name?
PKJ, Lordship.
Yes. Where the land is situated?
Setsa Zubza.
Yes.
Lordship, the location is mentioned in in para 2 of my petition.
Para 2.
Yes. May I continue, Lordship?
Which line? The name of the place is
Specifically,
it has not been mentioned.
Lordship, it's Lordship will find this in other documents also, Lordship. Here,
SECH
SECCHU
U Sechu
ZUB ZA
Sechu Zuza
Zubza.
Zutza. Yes.
It's more specifically being mentioned in para 2. However, in all the documents, Lordship will find that the name of the location also, Lordship.
Is it is in between Kohima and Dimapur?
Yes, Lordship.
Okay.
So, Lordship, NHIDCL has acquired some of my land for the construction of the four-lane road. And I have no grievance whatsoever pertaining to the compensation paid in respect of the land acquired for ROW, Lordship. However, during the construction, my properties which were situated adjacent and next to the ROW, my properties has been damaged, Lordship. This is outside the ROW. The present issue pertains to the land, the properties outside the ROW, Lordship.
Okay.
And Lordship may kindly see page 22 of my petition, of my writ petition. Initially, I wrote a letter to Setsa Zubza. Sorry, to Subdivisional Officer Setsa Zubza.
Yes.
This is my first complaint, Lordship. Married to Subdivisional Officer Civil Setsa Zubza Kohima. Subject: complaint against four-laning construction for disconnection of my private approach road and usage of the same by them for carrying on earth without my permission at Serra Colony, Setsa Zubza. Sir, with due respect, in reference to the above, the undersigned would like to convey my grievances before your authority for your kind early intervention. That, sir, in the first place, I would like to state that the area in my land where four-lane was to be constructed was already been compensated to me, and I have no complaint over the construction. Whereas the contractors, without my permission, is plying their vehicle through my private road, where they have no authority. That when I sent my people to stop them from plying in my land, where an approach road exists, and constructed by me at my own expenditure, they threatened my people, sorry, to go and complain in Guwahati or Delhi instead of trying to negotiate with me, the landowner. Now it is pertinent to say that work is going on at 2 points, which near Dera River above Ms. Rano Saiza's residence, and the other point is near Mr. Lipiu Rio's MP House Hotel. I have no objection at all if the four-laning of the 2 points meets through my land. I have objection if they transport away the excavated earth along the four-laning construction, but I have full objection for them to transport and ply in my private road. Moreover, my house is under construction, and now that they have disconnected my approach road, I could not transport the building materials to my construction site anymore, and the development work is totally stopped. Hence, I would like to request your esteemed authority to kindly intervene by, one, stopping them from thoroughfaring my private approach road, to let them reconstruct a new approach road to make it accessible to my land so that I will be able to transport the building material and complete the construction of my house, for which your kind early action, I shall remain ever grateful. Yours faithfully, the petitioner.
So your
In this first letter,
your grievance was that
yes,
your road was unauthorizedly used
yes,
and
that,
you were prevented from going to your place.
yes. My approach road has been cut off and it has been unauthorizedly, without authorization. The NHIDCL had blind my road. This is 2017, Lordship. This is in the year 2017. I have no grievances at this point, Lordship. I have no other grievances.
Okay.
I have not communicated my grievances, at least in my letter, Lordship. Yes. In 2018, again, after a lapse of 1 year, I've written to the Deputy Commissioner this time for the same reason, Lordship.
Yes.
Married, Lordship. To Deputy Commissioner KOHIMA, Nagaland, subject request for reconstruction of private approach road at Sir Colony, Setsazubza, that was cut off during construction of 4-lane. Sir, with due respect, in reference to the subject cited above, I would like to say a few words of my grievances for your kind intervention into the matter. That, sir, during construction of development of 4-laning, the approach road to my private land at Sir Colony, Setsazubza was totally destroyed. It is learned that there is an agreement between the government and the construction companies to reconstruct those existing approach road that were destroyed during the process of construction of 4-laning. In this regard, I would like to request your esteemed authority to kindly intervene by issuing directives for reconstruction of my private approach road at the earliest, as I am facing a lot of problem due to inaccessibility to my private land, and that my house construction works have been totally stopped for about 2 years. 2 years now, due to inability of transport the building materials to the site. Your kind action is sought, and for which act of kindness, it should be kindness, early action, I shall remain ever grateful. Yours faithfully, Hajjao said the petitioner. Thereafter, Lordship, SDO Civil Setsazubza has #24 of my petition in Annexure C series.
Yes.
The verification report submitted by married Lodge to the Deputy Commissioner KOHIMA Nagaland, subject verification report on the damages caused due to 4-laning works at GREF camp area Setsazubza. Sir, in inviting reference to the above cited subject as directed by your authority, the verification was carried out on the 15th of April 2018 in presence of affected landowner Sri Thejao Sekose, the present petitioner, and the head DB Setazubza. It may be mentioned that the height of the earth cutting for the highway in some portions are as high as 40 to 50 feet approximately. And this part is also important, Lordship. Because of the extensive nature of earth cutting for the highway, farmhouse and paddy fields belonging to Sri Thejao Sekose on the hillside is being affected by way of cracks and land upheavals, developing almost the entire stretch of his land. The extent of cracks in some cases being more than 500 and 600 feet away from the ROW. Properties affected. Piggery, number 2, under construction RCC building on the verge of completion. Number three, terrace field damaged by cracks and upheavals, thereby rendering it unfit for cultivation. Immediate threat. There are two HT towers falling within the land of Sri Thejao Sekose. In one of the HT tower, the base is already affected by cracks and upheavals, thereby posing grave danger to human lives. The other HT tower is just next to a household inhabited by a family. The landowner, as well as the undersigned, had advised the family to vacate and shift to a safer location as a precaution. Suggestions. The Department of Power be directed to visit and take safety measures of all at the earliest for the HT towers. Two, the NHIDCL contracting firm be directed to construct breast wall covering the entire height and along the entire stretch at the earliest in order to arrest further damage. But this was in 2018. Damage has already been noticed, and Lordship will notice that in the suggestion, the SDO has already suggested that breast will be constructed so as to arrest further damages, Lordship.
Yes.
Photographs, some of the photographs Lordship will find in page 25. This pertains to land erosion in my land, private land at Civil Colony. In the next page, Lordship, page 25, mostly, Lordship, this photograph is of the terrace paddy field, the upheavals and the damage that was done to terrace paddy field. Page 26. Lordship will find in the fourth page, fourth photograph, that the land in the ROW in issue, the ROW which was acquired from me, with that land, a box cutting has been constructed, and on both sides of the land, on both sides of the ROW, both sides of the box cutting, I have land on both sides.
You have land on both these.
I have land on both sides, but one side of the land is not developed. Only one side I have RCC construction, a 3-story RCC construction that was going on. The construction has started in 2012, and it has been on. It was on the verge of completion. I have a piggery project in that portion of land, and also terrace cultivation project. And what you will find in page 27 also some photographs. In the last photographs, to give a perspective of how the excavation work has been done. Lordship, the vehicles as compared to the how deep the excavation has been done, Lordship can get a perspective here. And in page 28, certain cracks were already there, even at this point, Lordship. This is inside the building. In page 29, Lordship, I have a proper piggery farm, and it's not just a mere piggery pigsty, Lordship. These are all RCC construct posts, and Lordship, as your Lordship will find in the picture, these are the piggery. Before my piggery has been pigs in my possession, Lordship, but I was compelled to sell off the and 32, these are also till 33, these are also pictures of the construction that has affected my land. In page 34, Lordship will find that the DC Kohima has forwarded a list of complainants, a list of names of complainants regarding compensation sought due to four-laning under Kohima district.
Yes.
Valid, Lordship. To General Manager NHIDCL, Branch Office Dimapur, house numbers so and so, subject forwarding of list of complainants regarding compensation sought due to four-laning under Kohima district. Sir, with reference to the subject cited above, I have the honor to forward herewith the list of complainants regarding the compensation sought due to four-lane under Kohima district. The list enclosed is prepared after field verification and found genuine. Therefore, is forwarded to the for your perusal and necessary action enclosed as stated. This was by DC and Lordship. In the next page is the list of the names of complainants, and in serial number 7, petitioner's name is featured. Kajao Sekose, Zubza, village Zubza. That's your Lordship.
Yes. Yes.
Yeah. On location, brief camp box cutting, nature of paddy field, RCC, piggery, remarks, retaining wall and approach road.
Okay.
The petitioner has written a reminder letter to SDO Civil, Setzazubza. Lordship will find this letter in page 36.
Yes.
SDO Civil, Setzazubza, Kohima, Nagaland, subject, reminder and prayer for restoration of my private road at Setzazubza, Zero Colony. Sir, with due respect, I am to state that as per my earlier position for restoration of the earlier existing approach road, which was cut off during the box cutting in my land, and four-lane, a spot verification for restoration construction of the approach road was conducted during the middle of 2018 in presence of the NHIDCL, Gayatri GPL, the contracting company, and the district administration. However, restoration of the approach road was not initiated by the contracting firm GPL till date. I therefore request your authority to kindly initiate with the highway authorities contractors for restoration of the approach road at the earliest. I am facing a lot of problems to approach my field. Moreover, the works in my half-constructed building was fully stopped since 2 years ago due to inability of transporting building materials to the construction site. Hence, the restoration.
Till now, you have not prayed for compensation. You have only
Lordship, in another letter, I've written that the government.
you have only prayed for reconstruction of your road which got damaged.
I totally agree, Lordship. Since the administration has started taking this letter was only for in respect of approach road, Lordship. However, in the next to the Deputy Commissioner, this is dated 18/4/2019. This is in respect and losses caused to my properties at Zero Colony, Setzazubza, due to excavation of earth of both box cutting while constructing the four-laning road. Reference verification report by SDO Civil Setzazubza, white letter so and so, the the same letter that I've read to this honorable court earlier. Sir, with due respect, in reference to the above cited subject verification report letter by SDO Civil, as referred above, I reiterated my grievances to you again, seeking justice for early payment of compensation for all the damages and losses incurred upon my property due to construction of four lane works. I'm hereby compelled to write this letter to state that a year have been passed since SDO Civil Setsa Zubza has written a verification report letter on 15/4/2018 upon my complaint. But till date, after a lapse of 1 year, no further action has been initiated to pay the compensation either by the government authority or NHIDCL, for which I'm surprised at their inactive attitude towards my grievances and to deliver justice. That, sir, during 2014, government have given me payment as compensation for the stretch of surface measured area of my land for the purpose of construction of four lane. But at this part of the 4 lane, a box cutting almost 25 meters deep was dug and excavated along the whole stretch, creating massive landslide to my land, affecting my terrace field, piggery farm, and RCC building. The affected area of my terrace field itself is more than 3 to 4 times the area of the compensated surface area, measured area acquired for construction of 4 lane. Thus, sir, I would like to request your benevolent authority to look into this brief matter and urgently conduct necessary evaluation on the damages and loss incurred upon my properties for early payment of compensation. Your kind early action is vehemently sought. Yours faithfully, the petitioner. So, Lordship, a year has already been lapsed. And during this time also, a lot of landslide, a lot of soil erosion subsidence has also taken place. And the land was affected even further, Lordship. The Deputy Commissioner has issued a circular. Lordship will find this in page 38. May I read, Lordship?
Yes, it is for joint verification.
Yes, Lordship. Joint verification, and NHIDCL has also been number one. Lordship will find that a copy was given to NHIDCL General Manager. The number 2 SDO Setsa Zubza. Number 3 SDO Housing PWD. Number 4 Land Records and Survey. Number 5 the FDB to serve all the notice to all the landowners to depute. These are fully FDB for the survey. Number 6 is the office copy, Lordship. Thereafter, Lordship, a land survey was carried out by District Land Records and Survey Officer, and the report was submitted to Deputy Commissioner, Lordship. Lordship will find this in page 40. LRSO's report to the Deputy Commissioner, page 40 of my book.
Yes.
Married, Lordship. To the Deputy Commissioner KOHIMA, submission of survey report of land damage of paddy field, plantation, excess cutting, and house at Zubza village, Zubza and Peducha. Sir, with reference to the Revenue Officer 2020 and on the subject cited above, I have the honor to submit herewith the survey report of land damage of paddy field, house and landslide at Zubza village, Zubza and Peducha, KOHIMA, after duly surveyed, checked, and verified by the technical staffs of this office. The area and boundaries as per the scale map enclosed herewith are ready for your reference, submitted for further necessary action, and closed scale map. This was written by District LRSO. In the next page, Lordship will find the sketch map.
Yes.
A survey of Nagaland scale map showing the detail of paddy field buildings damages by four-laning box cutting between kilometers, so and so, and so and so. Area paddy fields 25,250 square meters. For the first time, the area has been
This is the
measured and
area of the affected land,
area of the paddy fields affected land. Yes,
affected or total land.
affected, Lordship. The total land is about 18 to 19 acres, my land.
Okay.
Building is 306 square meters. The total is 25,556 square meters. 25,556. And reference, Lordship will find in the map that the ruled portion is the paddy field. And the plain portion is the ROW. Now the buildings are situated at the end of the paddy field, at the periphery.
Okay.
And Lordship will also notice that the affected paddy field is, even in this picture, is more than is about 2 times, at least about 2 times the size of the ROW. All these were affected, and it was lying unattended now because it was rendered unusable, Lordship. Thereafter, Lordship will find that the SDO Civil Setsa has again written to Deputy Commissioner Lordship will find the typed copy in page 43. Married, Lordship.
Yes.
Order number so and so, dated 27 January 2022. To Deputy Commissioner KOHIMA, Nagaland. Subject, grievances of Sri Theja Osekose at Sir Colony, Setsa. Sir, inviting a reference on the above cited subject, I have the honor to bring to your kind information that a letter 2017 and 2019, respectively, copy enclosed for reference, requesting for restoration of his private road, which was damaged by 4-lane construction activity. However, his request has still not been looked into, even after this office has verified his case in April 2018 and submitted a report for further necessary action. Therefore, his case may be looked into on priority since this case is a very genuine and long pending case. And Lordship will notice that a copy was also served to NHIDCL General Manager at the bottom, serial number 1.
Yes.
Thereafter, a comprehensive representation was made to the Deputy Commissioner by the present petitioner. This is a bit lengthy, but this is important, so may I read, Lordship? To Deputy Commissioner KOHIMA, Nagaland, subject 1, reminder to expedite payment of compensation for damages and loss incurred to my properties at Sir Colony, which was affected due to construction of 4-lane. 2, restoration.
Who is for the other side? NHIDCL and
In fact, Lordship, I have raised preliminary objections in this.
regarding
Lordship, firstly.
how much more time you will be taking?
Let my friend.
Lordship, I'll require some more time. Because besides this, my writ petition,
Will it be complete today? Because we have, say, 1 hour.
Yes, Lordship, yes.
No, we can
roughly 1
utilize,
hour,
we can utilize this time. And then if further hearing is required, we'll hear it tomorrow.
Yes, Lordship. Lordship.
Okay.
Tomorrow, Lordship.
No, day after tomorrow.
My Lord.
We have activities in the new complex.
Ah,
Yes, even myself, I have, I just.
for brevity,
what preliminary objection?
One, Lordship, before I come to the preliminary objection, Lordship, a pertinent issue has also been raised by this honorable court, Lordship, by order dated 4th of February, I believe,
What,
where none implement of necessary party, Lordship, because here there is a contract agreement between the contractor, Lordship, the person who executed the work, Lordship, for earth cutting and excavation and all those, Lordship, and the NHIDC, Lordship, that if wrong methodology is adopted and if any loss is caused, damage is caused to the NHIDC due to the adoption of wrong methodology by the contractor, Lordship, then the contractor shall be liable, Lordship. But here, despite them recognizing the fact that in para 7 of the writ petition as well, Lordship, they themselves have stated that Gayatri is the one who executed the work, but they are not implicated, they are not made a party here, Lordship. So my Lord is well aware, Lordship, that no adverse order can be passed behind the back of a party adversely affecting the right, Lordship. Then, yes,
okay, that issue we will address.
my Lord. And Lordship, regarding disputed question of fact, Lordship, because here we are disputing the facts, Lordship, the claim raised by the petitioner's, Lordship. And for this, Lordship, there is already an alternative remedy before. He may have a very good case, Lordship, but here we don't have the under Article 226, Lordship. This honorable court is ill-equipped to test the veracity of facts, Lordship, by conducting examination, cross-examination, my Lord.
No, but state is admitting that he suffered
yes, Lordship.
damages.
Lordship,
You are contesting that.
yes, Lordship, because Lordship, it is me who has to pay, not the state, Lordship. They may not have 101 things, Lordship. But here, Lordship, I am the party against which I'm the principal party here, my Lord. Regarding compensation, state is only a distributing authority.
Okay, we'll consider this.
My Lord.
Continue.
Lordship.
We'll
No.
continue day after tomorrow. Because today, unlikely it will complete.
Yes, my lord.
We'll continue for a
Can let my
time.
learned friend.
Let him complete.
Yes, my lord.
You may start day after tomorrow, both of you.
Because if I'm to address all the issues raised by my learned friend, in that case, I will also take some time, Lordship.
Lord, after I make my submission,
He can reply.
Afforded an opportunity to reply, Lordship.
Lordship, for the sake of brevity, I will not read the entire representation, Lordship. But
But
this
it is
representation-
also a repetition of what you have read earlier.
Yes, Lordship. This is more or less expressing my grievance for non-payment of compensation and non-restoration of my approach road. Lordship has already seen the photographs. Now there is no way that an approach road can be cut from such a height to my property now. So my buildings, my other property were rendered useless, Lordship. Lordship, during the pendency of this matter, Lordship, an interesting event happened, Lordship, and I must point this to your Lordship. Lordship may kindly see my affidavit in reply. Has your lordship got it?
Yes.
Lordship,
On
during
20
the,
November 2024.
yes. Lordship, during the pendency of this case, the NHIDCL has written to the Deputy Commissioner 2 times.
Okay.
And at the behest of the NHIDCL, Lordship, verification, measurement, assessment took place. Lordship will find these 2 letters in type copies in page 11 of my affidavit in reply. Married, Lordship.
Yes.
To Deputy Commissioner, the heading, NHI, National Highways and Infrastructure Development Corporation Limited, Ministry of Road Transport and Highways, Government of India. General Manager Projects, Project Management Unit, Dimapur, and the address. To Deputy Commissioner, Kohima District, Nagaland, subject, 4-laning of Dimapur Kohima Road from design kilometer so and so to kilometer so and so, existing kilometer so and so to so and so kilometer, excluding Dimapur and Kohima bypass in the state of Nagaland under SARDPNE through the engineering, procuring and construction EPC contract package 3, matter regarding damages and losses at Zera Colony near Grief Camp, Setzazubza under Kohima district registration. Reference so and so 1 and 2. Sir, with reference to the above cited subject and letter under reference above, for information of this office. Further, it is also requested to notify a convenient date, that is from 11th to 14th June 2022, for joint site verification, joint site visit to identify the damages and losses of Sri Tejao Sekose at Sera Colony, Setzazubza, for resolving the issue at the earliest. The cooperation of district administration in this regard is highly solicited on the subject. Yours sincerely, General Manager Ajay Batra, General Manager Projects, NHIDCL, and copy was given to Executive Director, Projects, SDO, Team Leader, and Office 5. Lordship will find the second letter in page 13. Type copies in page 13. To the Deputy Commissioner, Kohima District, Nagaland, subject, 4-laning of Dimapur Kohima Road from design kilometer so and so to kilometer so and so, existing kilometer so and so to kilometer so and so, excluding Dimapur and Kohima bypass in the state of Nagaland under SARDP NE through the engineering, procuring and construction EPC contract package 3, matter regarding writ petition 94 2002 registered. Reference and 3 reference were given. Sir, this has reference to the above cited subject and letter under reference 3 above which this office has requested to notify a convenient date for joint site visit to identify the damage and losses of Sri Tejao Sekose at Zera Colony, Setzazubza, for resolving the issue at the it is requested to kindly inform the earliest, the cooperation of the district administration in this regard is highly solicited on the subject issue. And accordingly, the Lordship on 16/2/2024, verification has been conducted in the presence of with NHIDCL and the other line departments, and attendance to that effect, or attendance of those who were present at the verification was taken on that date. The attendance is in page 14. Right copy is in page 15, Lordship. Mary, Lordship. As per the joint verification notice dated 16/2/2024 issued by the Revenue Officer, KOHIMA, for assessment of damages of properties belonging to Sri Teja Sekose, the following members were present and conducted assessment of properties at Sirra Zubza on 20/2/2024. Lordship, my apologies. The verification date is 22/2024.
Yes.
So the members present at the verification were number one,
NHIDCL engineer was also
yes,
present.
at serial number 8, NHIDCL engineer was also present.
Okay.
Yes. Besides, the other line departments were also present, Lordship. Lordship, just for reference sake, in page 16, I have another photograph. The person in white pants is the NHIDCL leading the measurement of and taking assessment of the damaged properties, Lordship. The assessment has been carried out. The assessment report, the estimation of the assessment of the building structures were submitted by the executive engineer, PWD, Housing Central Division. Lordship will find this document in page 17.
Yes. What was the quantum of the compensation assessed?
Lordship, for the building and structures, the total amount of the damages is amounting to 69,966. The petitioner's name is there. Plot number that is out of ROW. And the total of the assessment. Shall I read the breakups also?
No, not necessary. This pertains to your land only.
This pertains to my structures. Because my RCT structure is a 3-story building, Lordship.
Okay.
Yes. It has 10 rooms, 10 big rooms. And the piggery structures are also concrete structures. And also the forest department, DFO has also submitted his survey report. Lordship will find this in page 20. Report was submitted to Deputy Commissioner. Yes, Your Lordship.
Okay, okay.
The Deputy Commissioner KOHIMA, Nagaland, subject submission of survey report conducted at the private property of Thajau Sekosetsar Colony, Setsuzubza. Reference. Sir, with reference to the subject cited above and your letter, a joint verification was conducted on 20 February 2024 at the private property of Thajau Sekosetsar Colony, Setsuzubza. A detailed report of the survey has been enclosed. This is for your favor and kind information. Issued by, letter was written by DFO Chisai IFS. In page, from page 21 onwards, page 20. Page 22, Lordship will find a chart
On the
of the
trees,
trees.
this is in addition to what was assessed by the joint verification report.
Lordship, the forests were also present and they have taken assessment of the.
No, this is in addition to 9969.
Yes, Lordship.
Okay,
Yes.
okay.
So the total amount in page 22.
1393,052.
Yes, Lordship. And after the assessment was given to the Deputy Commissioner, the revenue officer has communicated this to the NHIDCL, Lordship. Page 26 of my petition, of my affidavit in reply.
Yes.
To General Manager NHIDCL Branch Office, Dimapur, reference number so-and-so, number so-and-so, subject matter regarding WPC Civil 94/2022, Thajau Sekose versus Union of India, the present case, abstract cost of property damages. Sir, with reference to the subject cited above, I am directed to submit here with estimate for property damage along with departmental assessment and survey report enclosed in respect of Thajau Sekose at Zero Colonies, Setsuzubza under 4-lane road project beyond ROW. Details are as below. Number 1, building category, building structures, amount 99,69,936. Plantation 13,93,052.5. Total 1 crore 13 lakhs 62,988. So this total assessment, besides this, Lordship, the property damages account, the total is, besides the
So
total.
ultimate total is 11647.
Yes, Lordship.
1 crore 16 lakhs 47 lakh.
Lordship.
1 crore 16 lakhs
After the
47,000.
deduction of other
Okay.
costs. Yes, Lordship.
Thereafter, what happened?
Lordship, after that, after the NHIDCL received the assessment amount, the estimated amount, then an additional affidavit has been filed before this honorable court again. And now raising certain issues because perhaps the amount that has been assessed along with them, the total amount was not palatable to the respondents, and therefore certain issues has been raised, and the defense taken by the respondent number 2 and 3 is that the only reason why the joint verification was conducted was only to see whether NHIDCL has actually it is the NHIDCL that has caused the actual damage or not. Instead of whether the damage, the joint verification is all about measuring and assessment of the damages caused to the petitioner. However, now taking a U-turn, the respondents, particularly number 2 and 3, they are now raising the issue whether it's NHIDCL that has caused the damage on. Now, Lordship, before the construction of this box cutting, there was no history of earthquake or landslide, land erosion whatsoever, Lordship. It is only because of the action of the NHIDCL that damage has caused to my properties. And in the first verification report itself, the SDO Civil, after verification, has given his comments that about 40 to 50, somewhere of the depth of 40 to 50 feet that has been cut for box cutting. And because of which, unless certain breast wall has been is constructed, further damage is going to be caused to the petitioner. However, that has not been done. Only this year, breast wall are the respondent are starting to come.
Has completed.
Road work has been completed, Lordship. The vehicles are plying now. Lordship, it is my humble submission that now at this stage, after all the assessment has been made, and now that they are not satisfied with the amount, perhaps they are not satisfied. Now can this honorable court go to the question of maintainability again? However,
No, but before deciding the matter, we have to address that question.
Lordship,
You must have some answers.
Lordship, I respectfully submit that, Lordship, Article 21 has been violated in the present case. In my writ petition, I'm invoking Article 21, 14, as well as Article 300A. Article 21, because, Lordship, the paddy field is of the magnitude, it's of a very big size, where 7 families used to cultivate the paddy field. Now it's rendered useless. It's left untouched now, Lordship. So my livelihood has been affected. And Lordship is well aware that from the case of Olga Telis and other subsequent many cases, the Supreme Court has held that livelihood is part of Article 21. Lordship knows very well. Therefore, now that damage has been caused to my paddy field, which is a main source of sustenance for my livelihood, it has been affected. Article 21 has been violated. Again, Lordship, in the same stretch of the road, in the same NH29, beyond the ROW, some other lands were been affected, and those landowners were compensated already, Lordship. I have annexed the documents, Lordship. Therefore, Article 14, my right to equality has see my affidavit in reply again, page 27.
Yes.
Married Lodge.
What is this?
This is the compensation that was disbursed to the landowners that were being affected outside the ROW.
Okay.
Others were being compensated, whereas I was not compensated, Lodge. Public Office of the Married Lodge.
Okay,
Office of-
we may skip it.
Sorry,
We'll take it that others whose
payment, Lodge.
payment were made to the other similarly situated persons.
Yes, Lodge.
Okay.
These three documents are important, so may I read, Lodge?
Okay.
Government of Nagaland, Office of Deputy Commissioner, Dimapur, Nagaland. Public notice dated 2021. Reference number so and so. This order is issued in Lane so and so, 25th January 2021, to inform all the beneficiaries affected due to landslide that occurred on 6 October 2020 at Perima village due to expansion of four lane, it should be 4-lane, national highway from Dimapur to Kohima, 124 kilometer to 158 kilometer at Perima village under Dimapur district, Nagaland, structures outside ROW. That compensation for damaged structures shall be paid in conference hall of the Deputy Commissioner on 27 January 2021 from 1 p.m. onwards. The chairman, head GB, and members of the concerned village council are hereby informed to be present in person for identification of landowners and beneficiaries, issue of NOC during disbursal of checks, failing which payment shall be withheld. All the affected beneficiaries are hereby directed to come in person along with identity proofs, bank passbook, original and Xerox, passport photos, 5 copies, etc. Payment to any other representatives other than the concerned person shall not be entertained. This was issued by Deputy Commissioner Dimapur. Lordship will find in the next page the statement of account. At the bottom, Lord. A statement of account, Dimapur, land compensation for NH 29, Dimapur, Kohima. Lordship, at the bottom, Lordship will find that brought forward.
Yes.
Brought forward, DEP, TFR, NEFT, serial number so and so. And next also, and right below that, NHIDCL. So the payment has come from NHIDCL account through NEFT logic. So the question as to who is responsible to pay the amount beyond the ROW is NHIDCL.
If the damage is caused due to their fault.
This is beyond the ROW. It was beyond the construction, and landslide has occurred because of the construction. It's for damages structures, plantations, crops, etc. affected beyond ROW at Perima village for expansion of 4-lane National Highway 29 from Dimapur to Kohima, 124 kilometer to 158 kilometer Dimapur, Nagaland. Perima is situated below Setsa Zubza, and there There is no other village between the two, these two villages. Right below Setsuzubza, the next is not village. On page 30, Lordship. Page 30 reflects the names of the beneficiaries. Compensation for damaged structures, plantations, crops, etc. affected beyond ROW at Perima village for expansion of 4-lane National Highway 29 from Dimapur to Kohima, 124 kilometer to 158 kilometer, Dimapur, Nagaland. And the beneficiaries' names were reflected. The properties damages were also what you will find in the backups, and the amount at the end. Yes. Those amounts were paid in different numbers, some 21 lakhs, some 13 lakhs, some 48 lakhs, so on and so forth, Lordship. Our Lordship, therefore, Article 44 that read lies. Besides Article 21 and 24, Lordship, Article 31A, I'm also invoking Article 31A. Lordship, I've been deprived from enjoying my rightful properties because of the action of the NHIDCL, Lordship. My land, my properties were rendered useless. Therefore, I'm deprived from the enjoyment of my own land. And Lordship is well aware that in such cases, although this is not a fundamental right, it's only a constitutional right, but in cases where the state has illegally deprived an individual from enjoyment of 2016 to GLT this order was passed by this honorable court at Itanagar bench, Dokmo lawyer and others versus State of Arunachal Pradesh and others. Lordship, this case pertains to livelihood, Lordship. In this case, Lordship, the BRTF, why canal, which is the only source of supply to a paddy field, a rice cultivation, which is a source of livelihood for the petitioners before the court. Now, sensing that the seriousness of the matter, the BRTF authorities, they have sanctioned certain amounts. However, those amounts have never reached the beneficiaries. Lordship, may I kindly see para 7.
Which para you are relying?
Para 7, Lordship. Very good.
Yes.
The unresponsive attitude of authorities concerning is highly discriminatory and arbitrary, and as such, they are liable to pay compensation for the losses incurred by the petitioners. The same act of the respondent authorities is violation of right to live with dignity and is a clear violation of Article 21 of the Constitution of India. Therefore, it is an obligation upon the state to secure the citizen and adequate means of livelihood and to protect the dignity of petitioners. As such, the respondents are liable to pay compensation. Again, para 14.
Yes.
Notwithstanding such clear findings, recommendations made by the committee concerned, the matter at hand is languishing till date without any headway. It is ironic to say that neither the state respondents could show any documents to support their contentions. Contentions that the said canal Nala has been reconstructed, nor that they have made any effort to it's also hard to believe that the petitioners, being active farmers of their locality, would refrain themselves from doing cultivation in their WRC field. In the state of Arunachal Pradesh, the main source of occupation villager is agricultural farming. Therefore, this court cannot believe the contention of the same respondent that the petitioners are not cultivating their WRC fields on their own sweet will. Para 20 logic. The operative part. It is evident from the materials on record that the BRTF authorities have sanctioned an amount in the month of August 2013 to compensate the loss caused to the Nala during the construction of the road in question. And prior to that, the petitioner were already deprived of their yearly income because of the non-farming of their agricultural land. And until the end of the year 2014, the petitioner could not have cultivated the land, which is the main source of income, for lack of proper facilities. And the same has resulted serious loss to the petitioners for this 2 successive years. And the same amount has been assessed by the office of the district agricultural office, which is very much on by the respondent authorities, nor the same can be discarded for any other reason dependent upon their agricultural land for their day-to-day affairs. Accordingly, it is found by this court and eventually hold that the petitioners are liable to be compensated with as prayed for. What should, in my case, since 2018, my land has been rented, my terrace paddy field, which is a main source of sustenance for my family, has been affected, and it is rendered useless till now.
Okay.
And I'm asking compensation for that. Lordship. The Supreme Court case.
Which para?
Lordship will find the facts in para 2, 3, and 4. 2, 3, 4, and 5, the facts.
And
This is about challenging illegal taking over of possession of private properties by the state. So it touches upon Article 14, 21 as well as 38, Lordship.
No, in your case, there was no illegal acquisition. Your case is that the land which does not fall within ROW also got damaged. Therefore, you are entitled to get compensation. They are liable to pay compensation who caused that damage.
Yes,
That is your case.
yes, Lordship. Only those damages caused outside the ROW.
Yes, and the assessment was made by after joint verification.
Yes.
No, you have not yourself assessed. It is the state
It is the state who has
who,
made the
who
assessment.
had made the assessment.
Yes, at the behest of the NHIDCL,
Okay.
the verification took place, Lordship. Lordship, I'm relying on para 17, 18, 19, and 20 in this case. Married, Lordship.
Yes.
17. Depriving the appellants of their immovable properties was a clear violation of Article 21 of the Constitution. In a welfare state, statutory authorities are bound not only to pay adequate compensation, but there is also a legal obligation upon them to rehabilitate such persons. The non-fulfillment of their obligation would tantamount to forcing the said uprooted persons to become vagabonds or to indulge in anti-national activities, as such sentiments would be born in them on account of such ill treatment. Therefore, it is not permissible for any welfare state to uproot a person and deprive him of his fundamental constitutional human rights under the garb of industrial development. The appellants have been deprived of their legitimate dues for about half a century. In such a situation, we fail to understand for which class of citizens the Constitution provides guarantees of rights in this regard, and what is exact percentage of the citizens of this country to whom constitutional statutory benefits are accorded in accordance with the law. The appellants have been seriously discriminated against qua other persons whose land was also acquired. Some of them were given the benefits of acquisition, including the compensation in the year 1996. This kind of discrimination not only breeds corruption, but also disrespects for governance, as it leads to frustration and to a certain extent forces persons to take the law into their own hands. The findings of the High Court that requisite records were not available, or that the appellants approached the authorities at a belated stage a slur on the system of governance and justice alike, and an anathema to the doctrine of equality, which is the soul of our Constitution. Even under the valid acquisition proceedings, there is a legal obligation on the part of the authorities to complete such acquisition proceedings at the earliest and to make payment of requisite compensation. The appeal, etc., are required to be decided expeditiously for the sole reason that if a person is not paid compensation in time, he will be unable to purchase any land or other immovable property for the amount of compensation that is likely to be paid to him at a belated stage 20. While dealing with the similar issues, this court in K. Krishna Reddy versus Collector held as under. After all, money is what money buys. What the claimants could have brought with the compensation in 1977 could do in 1988, perhaps not even one half of it. It is the common experience that the purchasing power of the rupee is dwindling. With rising inflation and delayed payment may lose all charms and utility of compensation. In some cases, the delay may be detrimental to the interests of the claimants. The Indian agricultural generally have no advocation. They totally depend upon land. If uprooted, they will find themselves nowhere. They are left high and dry. They have no savings to draw. They have nothing to fall back upon. They have no other work, and they may even face starvation unless rehabilitated in such a case. It is the utmost importance for the award that the award should be made without delay. And hence, the compensation must be determined without loss of time. In view of the above, the then case represents a highly unsatisfactory and disturbing situation prevailing in one of the most developed states in our country. Lordship, this pertains to payment of compensation in land acquisition case. However, in my case also, Lordship, Article 14 has been violated because I was not judged with the same yardstick. Secondly, my livelihood has been affected. And therefore, Article 21 applies in my case. Thirdly, my land is still being rendered useless. And also, Lordship will also notice that the verification report, earlier verification reports were not disputed, and none of the reports were being also challenged, Lordship. That's all from my humble submission, unless your Lordship requires any clarification.
Day after tomorrow.
Also, it can be on Friday, but I have fixed 3 criminal petitions before my lord on Thursday.
Not on Friday. Then it will slip out of.
Lordship, then let's give it a try on Thursday.
Lordship, my sincere apologies. I've missed one very important point.
Not,
I won't take time, Lordship.
not today. Which point?
The question why Gayatri was not completed. That
Ah.
has already been resolved by this honorable court, Lordship.
Yes.
Admittedly, I have not completed the contractual party. By the NHIDCL
Otherwise,
to
Lordship,
impede the Gayatri.
to be honest, Lordship, things are processing, the paperwork are processing for challenging that particular order for the division judge.
The IA.
Yes, the order passing the IA. I have received verbal instructions, Lordship.
Lordship, this, yes.
Because
But
now
you,
the issue
you,
is,
you have to
yes,
challenge the IA before main case.
before the division bench, the IA which was passed,
But suppose the main case is disposed of.
yes.
Can
Lordship.
you prefer
Yes,
an appeal against
Lordship, Lordship.
IA?
I agree, Lordship.
What has been held in?
Lordship, the court, this honorable court has already passed an order. DCL has filed an IA to impede the Gayatri, the contractor.
That was not allowed.
That was not allowed by this honorable court.
Which is the
And
IA number?
Lordship,
IA Civil 119 of 2024.
Order dated?
Order dated 22/8/2024.
Okay.
I have annexed this in my
Okay.
affidavit in reply in page 41.
Okay, heard, Mr.
Lordship,
Yes.
one more point. Besides that, NHIDCL, they have admitted that they are the principal in this construction work. Therefore, in any case, vicarious liability applies. When the agent work has affected my land, then the principal is liable for that, Lordship.
there is a specific agreement, Lordship. This is not only a simple relationship between a master and a servant, Lordship. There are also a separate entity.
Okay, heard, Mr. T. Keze, learned counsel for the petitioner. Also heard Mr. Im Song, learned sent additional AG appearing for respondent number 4, 5, and 6, as well as Mr. Senti Younger,
For respondents 1, 2, and 3.
appearing for respondent number 1, 2, and 3. Though the learned counsel for the petitioner has completed his submissions, the hearing remained inconclusive. Therefore, let this matter be listed again on 27th of March 2025 as part heard matter. You have to finish on that day.
Lordship, I'll do that, Lordship.
Otherwise, I will release it from PAO.
Lordship, I'll try my best, Lordship. Otherwise, Lordship, the 3 criminal petitions which I have fixed on Thursday, Lordship, those are very important matters.
Okay, let us see.
My Lord.
Earlier.
Item number 24.
Time is not there.
The matter being released after 2 weeks.
Heard Mr. Pakindri Chapo, learned counsel for the petitioner. Also heard Mr. Imteen Som, learned additional AG, appearing for the state respondent. Due to paucity of time, this matter could not be taken up for hearing. On request of learned counsel for the petitioner, let this matter be listed after 3 weeks.
After 2 weeks.
After 2 weeks.
Item
May
number
please, my lord.
29.
Yes. May I please, my
Item
lord,
number?
this is just a short matter, Lordship. So, Lordship can take it up on 27th or 28th. It's just a short matter.
28, I have already fixed a matter which may take.
So on 27th. It's just, it will not take half an hour because
Half an hour from your side.
no, on my part, it's either this honorable court intervenes. I have filed a case that I am the landowner. However, the government has stated that one of the family members has been already appointed.
So appointment on the basis of land.
Land ownership, Lordship. So just a clarification. Otherwise, the respondent number 5 was appointed through backdoor. So it's either this honorable court give a little bit of relaxation or advertisement for advertisement of the post. That is that's all, Lordship. Advertisement.
Let it come up next week.
Lordship, I have a personal feeling this, so if this matter will come up on 1 or 3.
1 or 3, I have already.
You discuss amongst yourself and choose a consent date. You suggested it.
Then next week, in that case, not a fixed date because I have lots of fixed matters
Yes,
pending.
yes.
So just
Heard Ms. Z. Zimomi, learned counsel for the petitioner. Also heard Mr. Imteen Som, learned
no, Lordship.
Miss Pichano, learned government advocate appearing for the state respondent, as well as Miss Mika H.I. appearing for the private respondent number 5. Due to paucity of time, this matter could not be taken up. Let this matter be listed in the next week on a date to be fixed by registry.
Lordship. Lordship.